Alan, I think we lost you for
to,
a second.
oh,
Hold on, hold on.
um,
Now you're back. See if you can go ahead and restate your question.
okay, I'm going to also shut down my email over here. So we had the law change several years back, said you have to disclose your equitable interest to the nature of your equitable interest to the potential buyer. And now they're adding, it has to be in writing, and you have to disclose the nature of your equitable interest to the seller. And I'm confused
To the
because
seller.
the contract is your equitable interest.
Right.
And
So
one would think prior to executing the contract, the buyer has no interest at all.
and the underwriters, we're running into underwriters who are requiring the seller to okay an assignment. Maybe the legislature was trying to do something like that, and they just goofed.
Okay, boys, I came in late. Alan, what are you talking about, big guy?
So the statute a while back in the occupation code 1101.0045, it was the wholesale statute. They said, all right, you have to disclose your interest to an end buyer. I guess they were running into problems where people were assigning over their interest but not disclosing what they were assigning, and people getting mad and such. So they passed that, I think back in 17 or 15 or something like that. But now there's a new change coming up where they say, A, it has to be in writing, and B, you have to disclose your equitable interest to the seller. And that's the part that confuses me.
That makes no sense.
Okay, thank you.
It makes you, by the way, I've had the privilege of being down in Austin, meeting our wonderful legislatures. You guys might as well have done the same back in 05, 07, and 09. And how they get anything done, I don't know. Because I hear things like Alan just threw out, and you kind of scratch your head and you go, what? They don't ask the guys who are in the business what to do or how to do it. They do it themselves, thinking they know the right way of doing it. And of course, they just muck it up even further.
Well, the
Alan,
senator who was passing
that's a call.
The senator who was passing the RAP legislation. What, me run?
Oh yeah.
Oh yeah. I felt like I had to shower 3 times after going down there and listening to those people. But the senator that was passing the RAP legislation, the first go around, it took her 3 times to get it done. The first go around, we said, well, where'd y'all get you? They said, well, we went to the big bank lobbyist and asked what they would want in RAP legislation. So they went to Wells Fargo's lobbyist. It didn't work.
Of course they do. Anyway, I get it.
Well, what's interesting is we have all of these laws that are being passed by all of these states. And I get, hey, disclose to the seller that you're a wholesale buyer and that you intend to, or you may assign the contract and whatever. Most of the time it's already in the contract that it's assignable and that the buyer may assign it. But okay, we'll make it in big bold letters so that the seller can, see it and initial it and do whatever so that we've met that requirement. What I don't understand is the disclosure requirements on the, assignment side. In Arizona, our legislature states that you have to disclose that you're a wholesale seller and you have to do it before you go under contract for the property. I'm like, well, if you're assigning it, you don't go under contract for the property with anybody unless you're going to double escrow, right? And so it doesn't make any sense, but they want you to assign it. But to me, all they're doing is they're ratifying what the law provides anyway, right? So if you're out there marketing your interest in the real estate, you are required by law to avoid committing fraud to disclose that you only have an equitable interest, that you only have a contract interest, right? Not only that, but the MLS regulations and the rules of any multiple listing service requires that you disclose the nature of your interest within the listing itself. So you can't go and say, oh, well, I'm the owner of the house now, and I'm going to list this property for sale, and I'm going to list it out there and publish it to the world as though I'm the owner. No, you have to say, hey, I'm looking to assign my contract. I'm looking to sell my contract. I have an equitable interest in the property. So these laws are just really codifying really what already existed, in my view, in the law anyway, and what your duty was when you were trying to find an end buyer and assign the contract. So I don't know, leave it to the legislature, like you said, Alan, to kind of mucky things up and, you know, create issues where, in my view, issues probably didn't exist to begin with.
Well, I have a bigger
Yeah.
concern.
But
And that is why is Sean wearing long sleeves?
Well,
Scott, it's 65 and rainy out. It's 65 and rainy, man.
Yeah, well, it ain't here, okay?
yeah.
I think we're on day 45 or so of plus above 100-degree temperature.
Well, yeah, Arizona just finished a record July of record number of days above 110. If this wasn't recorded, my wife, this shows you how bad it is when your wife sends you a bill. I got my electric bill for cooling the house, and that illustrated just how hot it was here. But Sean's way up in Wisconsin, so he doesn't have to deal with that right now.
Can I send you my bills too?
So
Go for it.
Yeah, unfortunately, I have
on that equitable
living
interest.
in my house in Arizona, and so I'm still getting the big electric bill. And it's big. It was the biggest I've ever seen, actually.
Yeah,
this last one.
Mine too. Alan, go for it. I know you were going to say something substantive.
So I'm seeing some scuttlebutt out there about wholesalers getting property under contract, so they have equitable interest, but they're going out there and listing those properties on MLS, which it's my understanding, at least in Texas, that's a big no-no for the agent to be listing that property for sale with that wholesaler's interest versus the actual owner. What do y'all know about that?
I have not seen that here in Texas yet, Alan, although I don't disagree that that's out there. These guys do anything they can do to maximize dollars. And unless the seller somehow contractually gives them permission to do that with their agent, you know, obviously it shouldn't be done. But until somebody cries foul or calls Trek or whatever it might be to turn them in, you know, nothing's going to happen.
I think they'll kick the agent off of MLS.
Yeah.
So in Arizona, you should get the seller's permission, and you're required to get the seller's permission to market, you know, your equitable interest and to show photos of the property and things like that in the MLS, you know, and market as part of the contract. And, you know, the wholesale contract should have that in there. But in Arizona, my understanding is the MLS, you can list your equitable interest in the MLS. You just have to make sure that you're very clear that that's what you're marketing, and you're not marketing the actual property. Because, you know, ultimately what you're selling is personal property. You're selling a contract. You're not selling the actual real estate. The result of selling that contract is the end buyer buys the real estate, but you know, you just have to be very careful how you word it. And so it's my understanding in Arizona, you can do that. And there's, you know, companies that charge flat fees to list it for you in the MLS. But they do want to see in the purchase contract that the seller has authorized you, especially to use like photos and things like that of the
You know what I would like to see?
You're going to use it, you have to market it.
Yeah. You know, I would love to see a requirement that if you are a wholesaler and you're going to a seller, you're going to put this property under contract and you're going to put up a whopping $10 of earnest money on this thing, that you need to disclose to the seller that you never intend to close on the property, that it's your sole intent to assign the property to a third party. Because what happens so often, I have no doubt that Alan sees this, Andy, you guys, Mike, Sean's just out playing around up there in the backwoods somewhere. But these wholesalers, they find these sellers, they're in trouble. They're looking for an exit strategy so often. They come in, they make this usually an overinflated offer in order to secure the deal, never with the intent to sell the property, which if they come to a title company, they want you to open title, which means as soon as we open title, it costs us money to open title. Either the corporate office or somebody's paying a fee to get that title evidence delivered, just to have them terminate the contract and walk away. But they don't care about the sellers. The sellers are out there, thinking they've got their deal done. And, 3 days before foreclosure, oops, we can't do it, and they walk away. I know that's not for us to talk about here, but I would love to see something like that go into effect just to protect the sellers and let them know what they're getting themselves into.
I think that's what the legislature was doing here in Texas, though. I think the legislature was trying to say, hey, disclose what your intentions are, not disclose your equitable interest, and they just goofed up, I think.
Well, run down there and set them straight.
I'll be right there.
I don't know what they're going to do.
Well, you've raised a good point, Scott, and that's the problem with this legislation is you have people who are lobbying and who are passing it that don't really understand this part of the real estate investment.
Well, let me tell.
They don't understand. For example, in Arizona, you have to disclose that you're a wholesale buyer and that you're going to assign or could assign the contract and may not be the one to close. Okay, great. But what's the penalty if you don't disclose? It's the contract gets canceled and the seller gets to keep the boo-hoo if it's a $10 earnest money, right?
Yep.
Now granted you lose maybe an assignment if it's a deal that you could really closed on, but at the end, there needs to be, if you really want to accomplish the goal, it's the legislation that you're talking about, Scott, where it's, make it that if you put that disclosure in there, that maybe there's a minimum earnest money deposit that you need to put down, that if you put in there that your intent is to not close on it and to, assign it to a third party, maybe the legislature should consider, and I'm sure we have investors watching are like, Sean, what are you talking about? But, at the end of the day, the industry will be ruined if you have these actors who are going out there and damaging the seller over and over and over again, right? You got to make sure that it's a fair transaction all the way around. And so if you have some legislation that makes sense, that actually has some teeth to it, requires the wholesaler to pony up more than say $10, I wouldn't oppose that. I think that would be fair and would make it so that, the industry continues to prosper and be viewed in a positive light.
I had a gal a few years back who was big in the wholesale side of things. And this was really at the advent of this wholesale explosion that was going on maybe, 3-4 years ago, 5 years ago, something like that. And things just exploded and went vertical on wholesale contracts all of a sudden. And it got to a point I said, stop. had to create all these new rules internally in one of our title offices, had to put together some documents to provide to the wholesaler up front that flat out said, we will not open title on your property until such time as you bring us the back end sale, unless you sign this affidavit stating that if you don't flip the contract, you intend to close the transaction and have the ability to do so. And, you know, I get if you do just one deal a month like that, that's one thing in an office somewhere. But if you're doing 80 like that per se, you can't do that. I mean, the amount of manpower and time that it wastes in going through all the cycles and whatnot. And what is unfortunate about the investment industry is it's all about money. It's the greed factor. It's the quick buck that everybody's out there looking for, I think. And unfortunately, these guys, especially the younger group out there who are more new to the industry, they don't think about the seller. They don't think about the closer, the title office. They think about one thing and one thing only, their assignment fee and how fast can we close. And they don't care what it costs somebody along the way. I know I'm on a soapbox here, boys. Forgive me for that. But that's what you see out there all the time, you know, in the industry.
Yeah. If you're just now joining us, everybody, this is the Creative Finance Collective. We are talking about creative finance, and right now we're talking about wholesaling. Guys, we do have a question. And by the way, if you're watching, we're taking questions for the hour. So if you got a question, creative finance related, or a question related to one of the topics that we work through, feel free to ask it. Like I said, we're taking questions throughout the hour. So Ivan asks, let's talk about novation agreements where there is a POA involved. MLS listing. What do you think? I'm in Texas.
So I was getting ready to say, just like Scott was talking about with the wholesalers, we're doing that with the novations now. When someone brings us a novation contract, we say, all right, we're going to pause until you find your end buyer. But we, the novations came rolling in, 12, 14 months ago. And I looked at it and I was like, well, this is just an assignment. There's no reason for it. But I looked into it further and I was educated further. There are benefits to it. Some of the wholesale laws are going to seep over probably to that, but I think the novation is a solution if they outlaw the wholesaling. But I've taken the contracts that were floating around and made a Texas contract for it. Those national contracts. One didn't call it a power of attorney. It called a authorization of something. What they were trying to do is get a power of attorney so that you can act as a real estate agent, like it's allowed in Texas under the statutes. So you get a power of attorney and you don't have to be licensed. You can go help someone. But they're not getting those notarized. And so I created a novation agreement where the seller is authorizing the agent to work with the investor novator in regard to the listing that's going to occur, as opposed to utilizing some type of half power of attorney, letting that investor go and list the property with an agent. So I've changed it around a little bit. The novations I think are good, allows you to get on MLS easy, allows you to find end buyers that can get conventional lending. Lenders aren't going to argue about an assignment fee. Underwriters aren't going to start arguing about assignment fees and getting approval of sellers. So I like the novation. Scott, I know you've seen them. What's your opinion?
Well, I'm writing some things down real quick. Hang on just 1 second for me. So 8-10 months ago, so almost in your time frame, Alan, you start seeing these things surface, right? Had a kid call me. He said, well, we signed a novation agreement. We paid $25,000 to bring the seller's loan current. We spent $8,000 or $10,000 doing the renovation of the property, and we can't find the seller. They've gone dark. And I go, what'd y'all do? you paid all this money and all you have is a contract, and they start taking a contract for sale and intermixing what looks like some type of a quasi partnership agreement inside of a contract for sale. And then they find out that the seller sold the property to somebody else. And of course, this is a seller that has no money. And just before that, I had a fellow I work with in Houston a lot, did that. Fortunately, he didn't spend that kind of money, and his deal worked out okay. And you hear this, and I'm just going, stop a minute, guys. What are you doing? You know, in Alan's point, if you're just trying to act as a quasi agent, do a few things to help sell the property in some format, along with if there is an existing agent involved, I get it. But what I see so often is where the seller is in distress, they're behind in payments, they don't want to sell their home with some creative finance mechanism. It may not be in foreclosure yet, and maybe the novator, if we want to use that term, they don't have the money to bring this loan current. But this house also won't pass appraisal standards without work being done to it. And so these investors are willing to put up all this money. I'm just going, first off, you're working on somebody's house and doing repairs to it. Do you even have permission to do repairs? Was my first question I asked along the way. Do you have a contract? I said, what if you get in and you do repairs and you mess it up? Are you prepared to get sued for those things in that instance or not? And I started bisecting this thing a little bit. And everything from bringing loans current to having to do repairs. And then they come up with this thing, and you can tell me if you've heard this too. It was a notice of interest that they wanted to file. And I said, what the heck is a notice of interest? And I read it, and it said, this says nothing. It's signed by you, the investor. It's not even signed by the seller. And I said, it's not even notarized. You can't file it. And if you do notarize it and you file it, great. Did the seller give you permission to file it or not? That could be problematic. Then I said, I want you to think about this. You have this notice of interest that says nothing. And if a title company pulls it up, knowing who escrow officers are, because you're not going to deal with an attorney when they open title. I can tell you right now, an escrow officer is going to look at a notice of interest and go, what in the world is this? And it says zip. And again, there's some guys, y'all, who are out of Connecticut, New Jersey, someplace, who are marketing this, telling people how to do all this with all these forms. And I looked at them, I'm just going, holy cow, guys, you are opening yourself up to huge liability. You know, you're marketing the property. Do you have permission to do that? Maybe, like as Alan said, you might, and there's some circumstances. 2, you're making repairs to somebody's property. Did they actually give you permission to go in and do it? And did you lay out who's doing it, who's paying for it? What if you don't pay your contractors and a mechanics lien gets filed on the property? Who's responsible for that? So anyway, I broke this thing apart about 16 different ways. And at the end of the day, what you see the investors trying to circumvent everything because they don't have the money or the ability to do the deal traditionally. You know, and if the seller doesn't want to do a owner finance transaction or even a short-term wraparound transaction, it was nuts. And so my suggestion was stop, control the deal. You know, if you want to control this property, do work, and there's payments to be made, form an LLC with the seller. Give them an interest. You have an interest. Transfer the loan into the LLC so the seller still has an interest in the property. If you're going to spend money on reinstating the loan, if that's necessary, if you're going to spend money on repairs, great. Then let the LLC agree to have you put a second lien on the property in some format. So now you've got the underlying mortgage protected and you have the The renovation costs and the reinstatement costs protected at least. Then, guys, through a corporate minutes or some corporate agreement, define what you're going to do, who's in charge of marketing, how you're going to market, and then how are you going to split the proceeds at the end of the day. And in all honesty, I have to go back and look at my notes, y'all. There were 4 levels of doing this, with what I just described being why I thought the best way is to protect the parties, at least out there a little bit. And no one wants to do this because they don't want to spend the money to set up an LLC or to do things of that nature along the way to do it the right way. They want to find the cheapest, quickest way to get it done without spending a buck if they can do so. But I went through and I created levels of this in some format for them. And based on who the seller is, based on what they can accomplish, down to where it's the bare bones. And it's just like, caveat emptor, beware what could happen. Your seller could run out on you, be dark. And good luck suing them, on a breach of contract, because they ain't got no money in most cases. So I think that the agreements I have seen out there, Alan, never seen what you've done on this before, but what was being published and sold nationally, apparently, this great idea, I looked at it and went, you got to be kidding me. I said, do not do this. You can do it, but beware the consequences. And, you hate to have a self-fulfilling prophecy when you said that, but just to have these guys call me out of Houston who had just lost, $30-something thousand, you're going, holy cow, guys. And it's just, they don't understand the risks that you can run into in our industry, it seems like. And they just don't want to come talk to an Alan or a Scott or an Andy or someone in that nature and ask, how do you do this the right way to CYA? They just want to move right on through it.
The contracts that were coming across my desk had all that stuff about you're authorizing us to renovate the property, and so I extracted all that out from mine. I say just do a sub-2 acquisition with a joint venture agreement. You take control of the property. Now you don't have all those associated problems. So mine, if someone comes and they're trying to do that, my answer is no. My novation agreement is exactly what it is. Hey, give me a contract to buy your house and let me go market your property. I'm going to keep the margin difference, and that's it. So it's kind of a bare bones now compared to what's out there. One fellow sent me. He said, "Hey, can you look over this novation agreement real quick and let me know how it is?" It was 87 pages long. I said no, can't do that. But yeah, it's if done correctly, I can see the benefit. But we got to get rid of all the wild contracts that are floating around out there. One says it gives them a power of attorney to sign the closing documents, actually sign the deed from the seller to the investor.
Oh yeah,
you can't do that, and it wasn't even a notarized power of attorney. So there's some crap out there, but if done correctly, I think it does have its bonuses, its benefits.
And I totally agree with you, Alan. There are, and here, at least for the guy who asked the question here in Texas, just understand what it is you're doing and what level of risk are you willing to take by putting up X amount of dollars. And if you're going to work on someone's home, make sure you've gotten written permission to do it. Make sure you lay out what it is you're actually going to do and realize you're doing it to somebody's home. At one point I suggested even doing a mechanics lien contract on the property. So at least you have a valid lien to protect the money that you're spending and putting into the house somewhere.
That's good idea.
All these things that I have seen along the way have been these guys who they want to get in, get out with as little expense as possible, to whatever the aspect might be. And at the end of the day, you just go, guys, you can do all these things and hopefully it works. It only becomes a problem when it becomes a problem. This happens, that happens, whatever it might be along the way. And, I'm going to bring this up again because I know we talked about this last week a little bit, Andy. And to me, it's this greed factor you just constantly keep seeing in the industry out there. More and more issues that are arising, whether it's, cutting the corner on the wholesale side of deals. It's large wholesale fees, doing this, doing that. It's trying to make that quick buck, trying to cut every expense that you can, regardless of the scenario. And the investors, they just want to run as fast as and loose as they can, I think. I've been dealing here just recently with, and I don't know if we talked about this last week, Andy, or not, there's these new people out there in the creative finance world. They call them connectors. Have you heard that term?
I haven't heard that one.
And this is somebody who connects an investor to a private lender. Okay, got it. So I started hearing that, first off, and we talked about usury the other day, guys, in Arizona,
Right.
that y'all don't really have it. Here in Texas, we do, where these investors, they want to have $0 in the deal. They don't want to put up earnest money. They want to borrow that. And the people who are lending the earnest money are charging 50% of that amount of money. So if it's a $5,000 earnest money fee, they might charge $2,000, $2,500 on top of that as their fee for doing that for 30 days. And so when you do the math, that's like pretty much 100% interest rate. Then, of course, they want to borrow money for the renovations. Maybe they're buying the house subject to, so they're getting a second lien. And in my situation, it was a second lien on a hard money loan that put the second lien holder in the deal literally at 100 cents on the dollar. And I look at that because they were charging a 20% fee of this $150-something thousand loan they were doing over a 4-month period. And of course, you look at that again, you're going, why is this happening? It's the greed factor of these lenders. They don't want to go out and do the work, but they want to earn $30,000 in 4 months just for lending money. Now, in this case, with the particular scenario I'm talking about, this poor investor who's out of the north is probably going to lose $50,000 to $75,000 on this deal at the end of the day, unfortunately. And you look at it, you go, what are you doing? But I see that in the investor world out there, and I see it in the lender world now, and this drive to, I don't want to have any money in the deal at all. I wanted to borrow this money to pay for my original down payment in the property. I wanted to borrow this money to pay for my the cost to pay back the investor and for some additional renovations I want to do. And you go, did you disclose that to anybody? Well, no. And then, of course, all this becomes usury. But I'm seeing a velocity of this in the industry. And it's just like, what and where is it coming from? So I don't know. And the novations is the same way. I think if you do it the right way, where you set it up right, you actually, your rights are done properly between your seller and yourself. And either do the JV agreement like Alan suggested, or for instance, on this notice of interest thing that these guys had, I went, throw that crap out the window. Let's change that. So you're directing an escrow agent, a closing agent, to pay a certain amount of money or a certain percentage of the net proceeds to you. Have your seller actually sign it, and get it notarized so you can record it so it actually makes sense and it's attached to something. But they still don't want to do that. And I just don't get it. Silence.
That's deafening silence of agreement.
God. I want to just bring up one more thing. This is to y'all's point earlier about state legislators back in and what they do and what they care about. Alan, were you out playing this game back in 2005?
Not 05. I sat out on that one.
So somehow, guys, back in 2005, I got the privilege to be nominated to be the president of this new thing called TexRIA, which was supposed to be our Texas lobbyist group. So I want to ask you guys a question. Tell me who an investor is in your state. Can you identify an investor? The answer is no. Let's make it easy. That was a toughie, I know.
It could be anybody and nobody all at the same time.
You got it. So the first problem with that was it's like herding cats, okay? And the other thing you find is that in our investor world out there, they all think somebody else is going to do the work for them, and nobody wants to put the money up to do the work because somebody else is going to do it for them. Anyhow, this was all surrounding the change of our lease option laws here in Texas. And we would go out and do our road shows throughout Texas to all the RIAs back then. And back in those days, guys, here in the Texas marketplace, we didn't have hundreds of meetup groups. What we had was, like in Austin, there was one main group in Austin. That was it. In Dallas, Fort Worth, we had one main group. In Houston, one group. San Antonio actually had two. Corpus Christi had one. Amarillo had one. Tyler had one. You know, today you come to Dallas, Fort Worth, there's 30 meetup groups out there, it seems like, and the same thing. So it was a little bit easier to go out and do the marketing along the way. But we finally got a team put together, went out to Austin, and went around meeting the legislatures. We hired a lobbyist who could at least help guide us a little bit, because there's a trick to the trade. But when you go out and meet everybody, you don't meet the senators, you meet their age, you give them information, you talk for a few minutes, and you're done. And there's 500 other groups there doing the same thing you're doing all at the same time. Now, in Texas at that time, just to tell you what it was, as they were going through this and having hearings on the floor, they didn't ask guys like myself to be there or other more professional investors who had a knowledge base to help steer them in the right direction. They called in the lobbyist groups like Acorn, which is a low-income lobbyist group in Texas in that regard. The investors went ballistic. They shut down the phone boards at the Capitol here in Texas. The governor actually reached out to us and said, stop them, and took some time and saw what was going on a little bit. But it didn't change anything, because at the end of the day, only one thing mattered. That was this group Acorn came up and said, well, we represent 10,000 low-income families, and we're for this bill. It's a bad thing. And even though 10,000 plus investors were voicing their opinions, it did not matter, because it was that one group. It was incredulous to see it. And we even tried to meet with the guy who was trying to write the law in Austin, and at least tried to steer him right. Not one thing we gave him was even considered, not just thrown out the window. It's interesting to watch how they do things down there, which I had no idea about. And it is truly an influence issue. So you have to go down and have a legitimate, number of people behind you in your group or whatever it might be that you can validate to get them to recognize you and actually even listen to you. Or what you got to do is have a pretty powerful lobbyist who can pull the right legislature aside for lunch somewhere, who will actually listen to you, that might sway something. But you look at what Alan is talking about the change here in Texas and some of these things. They don't listen to us. They listen to that one person in El Paso who ripped off people. 8 or 10 people got ripped off by one guy, and oh my God, we got to change the laws for the entire state of Texas. And it's always been that way, it seems. I'm not sure when it's going to change, but we'll see what happens. Okay, that's the last of my soapbox. Okay, y'all.
No more soapbox. You are grounded from the soapbox.
The legislature did a little bit better on the RAP legislation, but again, they just put so much weight in the big bank lobbyists and asking them questions, and they did let us come in there and have a bunch of investors gave some real life stories about how helping folks save their property and such. But my background's in litigation, and so bank lobbyist was up there, and I was up there at the same time, and bank lobbyist goes, well, if they go and wrap our mortgage, they go wrap our loan, it's going to make our foreclosure process more difficult. And so I said, how's your foreclosure process more difficult? You don't foreclose against a person, you foreclose on a property. And now you have two people that are responsible for paying your mortgage. So how is it a bad thing? And the commissioner says, counselor, you need to stand down. I was like, uh-oh, this isn't litigation. This is legislation. Yeah. So they do a little bit better job. I mean, they screwed the pooch on the lease purchase option statute. And case law has fixed it a little bit over the years, but the RAP legislation, they did okay. Not great, but okay.
No, I agree. But you're right. That you were speaking the truth.
Yeah.
And saying the exact right thing. They don't care.
No, you can't do that.
No, it's a whole different animal.
That was my mini soapbox, so I'll step off the soapbox too.
I'm going to mail you some of mine, okay?
There you go.
If you're just joining us, this is the Creative Finance Collective, and we're talking about all things creative finance. So if you have a question, make sure to leave it in the chat. We're happy to answer it. We were talking about wholesaling, novations. I wanted to pose a question to you guys over in Texas, and Sean too. Sean and I were talking about this yesterday on our show, and we've been talking about it a little bit more recently. And I'm curious to see, Alan and Scott, whether you've seen this in Texas, but talking about creative financing with an estate of a deceased person. So the hypothetical looks like somebody owns a property and they've passed away, and they've had an executor or personal representative, depending on what the state calls that person they're appointing on behalf of the estate. But we're talking about circumstances when it might make a lot of sense to do a creative finance deal if you're an investor, to come in and try to make that deal happen with an estate. And in thinking about a lot of the risk factors that are there in the common creative finance transaction, credit risk being a big one, it's not really it's not really there at all when you're talking about the credit of a deceased person. And if you're talking about taking over a 3 or 4% loan and assuming you're not going to carry any portion of the equity that's on top of it, it seems like there could be a lot of no-brainer deals that an estate could make in a sub-2 kind of deal. Are you guys seeing transaction or closing transactions with estates?
Yeah, just drafted up sub-2 docs for an estate today.
As the seller?
Yeah, the estate was a seller, and it's I kind of make the little joke of I've never had a deceased person complain about the problems in relation to a sub-2 transaction. So it lends itself, I think, quite a bit to a sub-2 acquisition or even a RAP acquisition, and so we see a bunch of them.
Yeah, like you, Alan, I mean, we see a huge amount of that. Of course, as all you guys know, it becomes problematic when you put heirs into the equation, because the question then becomes, what does the heir want? Is there actually equity in the deal or no equity? Is this thing heading toward foreclosure? What might it be? One of the biggest things that it never ceases to amaze me is the heirs have never talked to each other in the last 5 years, 8 years, whatever it might be. And then all of a sudden they find out that there's this house that mom or dad may have had, and there might be some money on the table, and the hands come out real quick. It's always that way, it seems like, if you can find them. But the key, I think, when you deal with an estate or the heir of an estate is whoever the person is buying that property, you've got to find a mechanism to get to the mortgage company and to communicate with that mortgage company as needed. And the mortgage company won't talk to anybody but the person who's dead. That might be a problem. Now, you guys aren't old enough to remember a movie called Flatliners, or are you?
I remember the movie.
Yeah.
So unless you want to play Flatliners and go meet somebody and get them to sign something, come back, ain't going to happen. And so you almost have to take either the letters testamentary in a probate, if they actually did a probate, which might be 10 or 15% of the time, because usually there's nothing done. And so you're left doing heirship affidavits most of the time. But we got to deliver that heirship affidavit to the mortgage company in order to get the information from the lender, because so often the heirs don't have it or they can't find it. So, if I'm closing a deal that's a probate, if they have access to information, if they have access to mom or dad's social and you can navigate some things online appropriately, I'm going to steer as clear as that mortgage company as possible, get the deal closed. The heirs can get paid their money. They don't care because, as you said, there's no liability, right? But if they don't have access to it, you got to get the information, you got to provide it to the lender and handle it appropriately in that instance, just so that, that they won't call the loan due, but if it's not handled right in the right format, it can happen. But we see a lot of that. And it is a good point, as you both pointed out, where they don't have any liability.
Yeah, it's interesting. Because I haven't done one, hadn't thought about it from the perspective of, in the normal transaction, you get the power of attorney or authorization to speak to the lender. But when you've got letters testamentary where it's been, the court's appointed, a new person to step in and act on behalf of the deceased, what power can they convey to a third party that might want to communicate with the lender like that? That's interesting. How did you handle that?
Did I
Alan?
just hear you say you've never done one of those?
I haven't done one with an estate. No.
Alan, we need to go to Arizona and teach these boys how to do this, okay?
We'll start. We'll get a little video and sell it on the internet and make millions.
$10,000 for y'all today. Special introduction offer.
Yeah.
I've seen lenders accept the authorization from either the heir via affidavit of heirship, and then that heir signs an authorization, or the executor or what have you. So I have seen them accept those and abide by that authorization request. But another issue comes up is when that investor buying that property then goes and sells it to an end buyer, and that investor goes away. Now we've got no access again to the mortgage company.
Yeah. By the way, I actually like those because you have limited liability. You even have more limited liability if the person is deceased. And if it's handled right, it's sometimes a little bit easier along the way. You just need to make sure you have access to that one heir. You provide them the heirship affidavit to the lender. Make sure you have the POA or authorization from that heir in order to communicate with the lender. Move on. And from there, it's pretty much a standard sub 2, I think.
Yeah. We've got another question. Question: seller's father and stepmom are on title and the father passed. Stepmom is mentally incapacitated with Alzheimer's, and the son has I assume that's power of attorney for her. Is probate necessary? Of course, I have no idea what state this applies to, and what we would say is you need to talk with a lawyer in your state to vet that out. But did the question make sense?
Yeah,
Yep.
I think it doesn't matter what state you're in, because you're going to court. You're going to either probate court or getting a guardianship for that owner of the property. period. There's no choices. That power of attorney, I guess depending on how it's written, but we have to ratify the power of attorney when we're using it for a closing. And so if they lack capacity, they can't ratify.
Well, Alan, let me throw this in there a little bit, and maybe you're talking about a different situation, but if I know that there's a father and a stepmother, and then there's a child. So I don't know whose child this is. Is it the mother's, or is it the father's, or is it the child of both? What we do know is that there's a prior marriage. And so assuming that the father passed away and not the mother, assuming that the child is either the child, if the child is the child of the mother only from a prior marriage here in Texas, then mom gets 100%, and there is no other children on dad's side. Mom's going to get 100% of the property at that point. Now, if the son out there,
if it's stepson though, if it's stepson, it's father's son and mother's stepson. So
Yeah.
there's a
50-50.
child outside the marriage. So now we're splitting it up differently.
yeah, now you're 50-50, but the son should be able to go ahead using the POA for the mother, to sell the property. Now the proceeds still go to mom 50% and son 50%. But I think you could navigate that without going to court in that scenario if the fact situation is correct. The question just comes down is that, you see these things and you've got to get the right fact scenario. So you work off of a limited deal like this. You don't know all the details to answer the question correctly, because you may wind up, either getting a guardianship, or if there's a will, a muniment of title or something of that nature. I don't know.
Our underwriters are requiring some type of evidence that mom had capacity when they signed the POA, also asking us to ratify that POA. And so that's why they end up going back over to the court side.
If you've got a good POA notarized properly at the right time, et cetera, probably okay. But if not, then I agree with you. We can all see what some heirs do out there or other people do. I mean, I don't know who's going to notarize it, if the son forges the mom's signature or something, but I'm sure for the right amount of money, somebody will do something like that, right?
Mm-hmm.
Yeah, I think we see enough of that out there from time to time.
And we did have a deceased party sign a general warranty deed one time.
Wow. Did you see it?
We
witnessed them do that.
We suspect it might have been the son, maybe, but
Maybe.
it was the deceased owner.
Yep. But they don't think about, sometimes the dates don't quite match up, or things like that just don't quite match up, but they don't think ahead. No, I think
I agree with you. If that POA, our underwriter probably is going to ask for some type of medical opinion that she had mental capacity at the time she signed it, and you might be able to navigate that without going to court. Yeah,
I get it. But what's interesting, guys, is when you get in that scenario, Andy, like in my scope of business, which is seriously just our law office in the creative finance world, foreclosures, et cetera, and title, I don't try to get too far out of those lanes. I'll never do what Alan do, which is litigation. I want to stay as far away from that as possible. You got to be kind of mentally deranged to want to do that anyway, I think. And that might fit Alan pretty well. I don't know. But I was going somewhere with that, and old timer sinks in real quick,
Well, I will tell you, I try to steer clear of all litigation now, but I got stuck in a case up there in your neck of the woods, and maybe I mentioned it before, where this attorney came in. His client bought the note at the last minute, and he doesn't appoint himself. He files no notice of appointment of substitute trustee, and goes down and conducts the foreclosure. And so I thought, well, this is going to be easy. I'll just let him know he goofed on this one. Need to be careful. You can get sanctioned or what have you for doing something like that. And that was 18 months ago, and I'm still embroiled in litigation because the darn statute is so ambiguous in regard to, do you have to file a notice of appointment of substitute trustee? When they changed it and allowed you to file a foreclosure combined with the appointment of substitute trustee, the statute kind of forgot to say, if you change a substitute trustees, you have to actually notice it. And so we're up there fighting about that still. So I agree with you. No litigation. This is my last one.
But with this probate stuff and things, you will see. I get a chance to see this as the title guy daily. I'm sure Alan does the same thing. It's incessant if you're in the investor industry, but you also see it on the outside if you're the investor out there buying, or the lender, what it might be. And it's just a nonstop blur of things that exist, whether it's, situations where there are 29 heirs and they're trying to flip a $10,000 piece of property and you need 14 heirship affidavits and it ain't worth it, to you name it, everything else in between out there. But the goal, I think, for guys like us in our industry is to help be that reasonable solution to the client when they call in, because we all know that these, especially in the wholesale world, they'll get one signature of 4 or 5 required signatures, file their memorandum, and think they've got a done deal, which of course they don't. And then you got to navigate all the probate issues and try to put it together for them. And sometimes you can do that, and sometimes you can't. Sometimes you're stuck where you can only get maybe 2 of the 4 heirs to sign, or you can't find the other 2 heirs, or whatever the situation, or they don't want to sign. And then you've got to decide, well, is it worth going another direction or not with that transaction, and kind of rolling from there a little bit. But just to kind of help you finalize things, Andy, I think in the probate world, buying a deal sub 2, where the borrower is deceased, the heirs oftentimes don't realize, in fact, I'm dealing with this right now, they don't realize they don't have any liability. And they think that they signed something somewhere, they're taking liability for taxes or yard maintenance or something like that.
Yeah.
And that's not true. And so you've got to be able to educate them appropriately, or have your investor client be able to educate them appropriately, which means we got to educate the investor on that.
So we only got about 1.5 minutes, 2 minutes left. I don't want to keep you guys, but another one of your boys down in Texas. You guys got a good Texas contingent down there. We got a question. See if we can answer this for him, or if we can give him an answer. I have a client that is acquiring a property. Seller's name on HCAD doesn't match the title search. Seller said they paid cash, but there is no record of the deed. Is there any way to correct this? Apparently this is in Texas.
Well, the CAD doesn't control the property records control. And so if the property records don't have something showing they're the owner, they need to get it. They need to get a deed. Just simple as that.
In the short time we got, good answer. Show me the deed, right? It doesn't have to be recorded to be valid, but we need to get it recorded. So either you got a deed or you don't got a deed. And so if you don't, you go back to whoever the prior owner was under, the deed records, and that's the person you want to go to and get your contract with. Otherwise, there could be a small little issue there, maybe.
Yeah. All right. Well, thanks so much for being with us, guys. We appreciate it. We know your time is valuable, and looking forward to going through more of this stuff with you guys in the next Creative Finance Collective. And if you're watching, a group of lawyers get together every Wednesday at 5 to talk about creative finance and answer your questions. So make sure to join us. We'd love to have you and answer your questions. You guys stay safe out there.
We'll try to stay halfway cool. Sending you our power bill, okay?
Yeah. I'll just forward it to my
We'll
wife.
see you guys.
All right.
We'll see you next week.
Everybody soon.
Bye.